So this coming session is democratizing asset return, which hopefully is quite a provocative title, because anyone who's had direct experience with the asset return processes know that they're not exactly places that are brimming with democratic participation, and often there is an extremely it's extremely difficult for civil society or the wider public to participate in any meaningful way in the asset return process, with state parties keeping their cards often very close to their chest. But obviously, there is a lot of good work being done to challenge that. And so on that note, I'm really looking forward to the set of papers being delivered today that really look at the innovations and possibilities that are emerging for civil society and public participation in the asset return process, which is obviously a pretty critical linchpin for achieving a lot of the other principles of good practice in regard to asset return, with things like accountability and achieving justice. So we have a really fine and illustrious lineup of papers today. The first to kick us off will be Recasting Accountability, Responsible Asset Restitution by Empowering Non-State Actors, delivered by Catherine Wilkins, who's is a PhD candidate at the Hertie School in Berlin, where her research examines the international anti-corruption enforcement architecture. And Catherine comes to Hertie with more than 10 years of experience and regional expertise on civil society empowerment to expose and contest corruption in Russia, Eastern Europe, the Southern Caucasus, and Central Asia. And I can speak firsthand in saying I've worked with Catherine before, and she's an absolutely wonderful colleague, and we're very lucky to have her here today, and I'm looking forward to her paper. And I've also been very fortunate to work and hear the fine research done by our second participant today, Dr. Prosper Maguchu, who's at the Free University in Amsterdam. And his paper is entitled The Role of Civil Society Organisations in Asset Recovery in Zimbabwe and Beyond. And Prosper is a project manager on the Rule of Law program and an assistant professor in the Faculty of Law. He teaches courses on a wide range of issues, including human rights, financial crimes, and transitional justice. And critically, Prosper's a lawyer by training, and he began his career as a human rights lawyer in Zimbabwe, where he represented victims of human rights abuses. So we're really fortunate to have Prosper with us today, and we look forward to his paper. And then to take us home, we have Dr. Ariadna Ochnio, who is delivering a paper entitled The Rights of Crime Victims to Recovered Property in the Polish Legal Order, Present State and Challenges for the Future. And Ariadna is an assistant professor at the Institute of Law Studies of the Polish Academy of Sciences in Warsaw, and her research interests involve EU criminal law, EU asset recovery, AML and CFT, anti-fraud, anti-tax fraud policy, and guarantees of a fair criminal trial. So we really look forward to her paper too. Just to finish off before I hand over to Catherine, just to say, obviously we're keeping the audience's mics muted just through the course of the presentations. But if you have any questions that you would like to ask of the panelists, I'd encourage you to write them in the sidebar, because we don't want to lose that moment of inspiration when it strikes you. So please do add it to the sidebar, and we will then, and then I'll read out those questions at the end of the papers so that our speakers can respond. So on that note, I will hand over to Catherine to kick us off with her opening presentation. And so Catherine, take it away.
Thank you, Christian. So I'm just going to share my screen really quickly. One moment. Okay, can everyone see my slides?
Yes, that comes through loud and clear.
Does it show the individuals? Is that in the way for you?
Sorry, let's just repeat that, Catherine.
Just making sure nothing's in the way of it for you, because it is on my screen.
No, we're seeing
Okay.
it really clearly. There's nothing blocking the slide.
Perfect. Thank you. So hi, everyone. I'm Catherine. I'm a second-year PhD student at the Hertie School in Berlin. I'm glad to be here today and to have the opportunity to engage with you. The earlier set of presentations and discussion was really interesting, and I'm looking forward also to the conversation tomorrow. So thanks to CFAR and ISKI for having me. My research examines the global anti-corruption enforcement regime. And while a lot of scholarly inquiry and policy work is oriented to the development of the correct technical interventions, or examines how to properly align resources to those interventions, indeed, this conference is evidence that there's a lot of work and a lot of innovation being done in both of those domains. What I'm personally really interested in is the power and politics of the enforcement regime, which actors are empowered and why, and how certain interests are reflected over others in the orientation of the framework. So my talk today is titled Recasting Accountability: How Globalization Drives Normative Alignment on Responsible Asset Restitution by Empowering Non-State Actors. I have 15-20 minutes for the talk, and I've timed myself, so I think it'll actually take me about 15. I'll provide an introduction to the topic, describe the approach, and offer some observations from spotlight cases, and then close by outlining where the research could go next. So, oops. Okay. Let me begin by underscoring that it's exciting to consider just how relatively recent anti-corruption as a clearly defined governance norm is, and how rapidly it's expanded in scope, and how quickly it's spread globally. You have the initial articulation of this norm presented in 1977 with the passage of the US Foreign Corrupt Practices Act. And then around the turn of the century, you see major formalization of rules, including the state-centric legal basis governing asset recovery and return contained in the UN Convention Against Corruption. Scholars have reflected on this development of the anti-corruption field and made two important observations. One, that the technical focus on corruption as a transaction has come at the expense of foregrounding structural changes to address its systemic nature. Secondly, across the field, scholars observe that there's a trend against legal technical interventions and toward political or normative approaches. For asset recovery and return, it is civil society organizations that have really been the pioneers in recasting the norms for return, pushing the paradigm from a managed transactional event to one that has enhanced standards and criteria, like centering people as the victims of corruption and prioritizing principles like non-reoccurrence, encapsulated in the term responsible asset restitution. Now, why contextualize questions about norms for asset return against globalization? Globalization simply helps explain how normative contestation, change, and alignment is happening. It's the backdrop. The economic, political, and social transformations that characterize globalization place demands on the state to act outside or beyond its exclusive purview, and also creates incentives for the states to rely more on non-state actors. When I say that already, you may be thinking of certain areas where this dynamic is readily apparent, such as in voluntary cooperative initiatives like the UN Global Compact, or in the wide usage by states of non-governmental or private organizations as grantees or subcontractors to carry out technical assistance and development work, or even in collaborations between national authorities and NGOs on the enforcement side, such as the pipeline for NGOs to submit informational dossiers to law enforcement institutions for instruments like sanctions. If renegotiation of the domain of the state and a rise in incentives for the state to partner with non-state actors is a broad trend in the anti-corruption field, how is this trend then playing out in the asset recovery and return space? At the normative level, it's led to contestation of the legitimacy of the requested state as an exclusive executor of a return process, and of the requesting state, the state demanding assets back, as the only legitimate recipient. Instead, a new norm has been introduced, that of responsible asset restitution, not merely a return on paper, but one that follows certain principles. Those include centering the people of the state rather than the state itself as the legitimate party that's owed restitution. That return necessitates taking into account the anti-corruption environment in the country, and that non-recurrence is an aim that should be embedded in the return framework. So there's a practical side to this and a principle side. On the practical side, the track record for returns has not been without blemish, and civil society organizations have evidence they can use to make the case that states carrying out the return need to change their practices. On the principled side, the increased need for participation by CSOs in the recovery and return process has created space for their version of the norm to be promoted, for this conceptualization of the norm to be adopted by policymakers and within institutions, and for the alignment on norms. Well, in the first instance, use of the same language. So where do we see this normative language being used? Can we see any normative alignment in practice? To explore this question, I took a look at 3 country cases: the Stall-Yanukovych case in Ukraine, the Abacha case in Nigeria, and the Obiang case in Equatorial Guinea, to see if and where the normative language used and promoted by civil society organizations has begun to be reflected elsewhere. So why these cases? Well, for one, I selected them because they'll be very familiar to most everyone in the room. Some of you have been actively working on leading developments for these cases. Secondly, there's comparatively a lot of coverage for these cases versus some others, and so there's some richness in what sources we can look at. For this exploratory examination, I looked at about 125 data points from 4 main categories of sources: CSO statements, institutional documents, strategies, press releases, and individual policymaker statements. We can examine the language employed. Do they contain certain criteria that reflect the practice of responsible asset restitution? For example, do they use words like the people of a country, not just the country itself? Do they mention if there is lack of institutional integrity in the country, or whether external monitoring, including by civil society, is needed? Finally, do they mention aims beyond the technical step of a return, such as reducing the likelihood of recurrence by creating a sustainable anti-corruption environment? To give you some insight into what this looked like, here are examples from each case that I found particularly revealing for different reasons. And I recognize that you might be able to not read the small text, so don't worry, I will explain. The first is a tweet from first-term Congresswoman Sarah Jacobs from the US state of California, an accomplished woman before entering office last year, but from everything I could find, her background is not centered on asset recovery. She writes, "For too long, corrupt officials in Equatorial Guinea have enriched themselves at the expense of the people. That's why I sent a letter with Representative Maria Salazar and colleagues urging the DOJ to share its plan to repatriate assets stolen by Ngembe Obiang to the people of Equatorial Guinea." So I think this is a really great example of norm diffusion. A legislator who has been exposed to and adopted this norm, making a statement in their official government capacity on the case and advocating to the US DOJ, and not just sending a private letter, but also making a public statement. Next to it, you see some text analysis of the 2017 MOU, Memorandum of Understanding between Nigeria, Switzerland, and the World Bank for the return of Sani Abacha's assets. The highlighted sections read, "The sustainable use of the restituted funds for the benefit of the Nigerian people, carried out in an efficient and accountable way, and lastly, that satisfies the scrutiny of civil society organizations." In fact, this is in the preamble, so you can see that responsible asset restitution criteria are in fact foregrounded in this document. Lastly, I mentioned that this case is stalled. Lastly, you see an excerpt of the current official 2-year strategy of ARMA, the Ukrainian Asset Investigation and Management Agency. ARMA is charged with detecting, investigating, and managing assets from corruption. So you might be surprised that among the 6 strategic goals and 21 sub-priorities, in this official strategy, there's no mention of any of the criteria we might expect to see. That doesn't preclude that such goals exist, or even that maybe these norms are already embedded in the culture of the agency, but it doesn't signal them either. Instead, it shows that there remain gaps in centering these norms, even within key institutions. So what did I observe across the 3 cases? On the positive side, standardization of normative language across sources. You see the same phrases with the exact same formatting, etc., coming up again and again. Also, that these norms are beginning to be reflected beyond the group of people, organizations, and institutions actively involved in the case. On the negative side, some limitations. We, of course, can't draw inferences from this about which concrete civil society efforts drive diffusion of the norm. Oops, sorry. Which civil society efforts drive diffusion of the norm. Also, in some cases, I observed an open conversation around nuances of the norm. For example, debate about whether certain classes, such as the most vulnerable or those harmed by prior regimes, might be more deserving of restitution than the general population as represented by the people of X. And then to briefly pick up on something raised by Professor Lassett at the beginning of the conference, something else I did not observe was any mention of the necessity for the requested states, that is the states that are sending back the assets, that are holding the ill-gotten gains, to themselves undertake reforms to prevent recurrence. That was entirely absent. That's an important gap and one that I think remains still ahead in the development of the norm. So I've conveyed how globalization can help us contextualize why and how norms on responsible asset restitution are in the process of alignment, and presented highlights from a preliminary examination of 3 spotlight cases. The next stage of this inquiry would be a more robust quantitative text analysis, either with more cases or expanding the volume of data for the spotlight cases, and then deepening the analysis, maybe making network diagrams of where the norms are present and where they remain absent. I think doing that could identify gaps and potentially offer insight into where further advocacy is needed. That's all, thank you, and I look forward to our discussion.
Brilliant. Thank you very much, Catherine, for a very well-organized, well-timed paper, and also very enlightening. So I'm sure there'll be some further discussion on that in just a moment. But in the meantime, we'll move on to the second paper of this session. And to do that, I'll hand over to Prosper to kick us off with his paper on the role of civil society organizations. Great, we can see that perfectly.
Good, I was trying to unmute myself. And once again, good afternoon, everybody, and thank you very much, Chair. So my name is Prosper Maguchu. I'm from Zimbabwe. I studied my legal career as a human rights lawyer. So you will see that I will always, include a human rights perspective in anything, including in asset recovery, which, by the way, should also be carried out on a human rights from a human rights-based approach, according to the UNCEC. But today, my talk, or within the next 15 to 20 minutes, what I'm going to do is to talk about the role of civil society organizations in asset recovery, focusing on Zimbabwean civil society organizations, both those that are based in the country and international networks or other affiliates or chapters or any organizations linked or working on Zimbabwean issues outside the country. By the way, this is also not a random picture. What you're seeing is in Zimbabwe, despite having sanctions on Zimbabwe, the EU having sanctions on Zimbabwe, and that Dutch plans to ferry goods that are brought manifestly by process of corruption to Zimbabwe. So another issue, maybe not for today, but also something that we need to take into account when talking about the role of destination countries in regards to asset recovery. Before I do that, I want us to just have, so to make sure that we are on the same page, this is a humble worm's eye view of my presentation today. I will divert a little bit, and I beg to divert just a little bit to talk about the link or the relationship between corruption and human rights. I like to call it a relationship between corruption and human rights. Then I'll go into the belly of the beast, my presentation. I'll talk about briefly the key challenges that the state is facing when it comes to the recovery of assets. This will then open the door for me to discuss the role that CSOs can play, non-state actors in this case, civil society organizations can play to then assist the state that is struggling when it comes to recovering assets, mainly from the proceeds of corruption. I'll then go into a brief conclusion and present a few points for further discussion. Okay. No violent objections. I can see some nodding. But then also I'm just in 1 minute, can you please just let me know, what do you know about Zimbabwe? I wanted to use one of the survey tools, but I guess that it was going to take us too much time. What I'll do is I'll stop sharing my screen just briefly, and if you can use maybe the chat box, just write any word that comes to mind. Don't overthink. What do you think? You know, if you just say the name Zimbabwe, what comes to mind? You can also unmute your mic and just say whatever comes to mind when you're the name Zimbabwe. I don't see anything in. Oh, Mugabe, yes. Mugabe. Oh, very important. Yeah, of course. Yes, there's Mugabe. What else? Yeah. History or something. Yeah. Okay. Oh, what about others? Was that Adriana? Catherine, what do you think? Yeah. What comes to mind? Or can I ask Pedro, Brianna? Yeah, authoritarian politics, also very important. Yeah. Okay. Anyway, I will save us from too much thinking anyway, and let me get back to sharing my screen. So, is this the one? Where am I? Okay. Let's share back. I'm just really trying to finish in the next 20 minutes. So yeah, Mugabe was an autocratic leader, and there's something that autocratic rule is, well, we're talking about democratization or democracy, corruption, asset recovery. You can see there is this unholy alliance between autocratic governance, dictatorship, and the looting of assets. Zimbabwe, there's one thing also that I must share. So Zimbabwe is, well, according to myth, is probably that which is referred to in the Bible as the land of Ophir. The land of Ophir is land where King Solomon used to get on every year chariots of precious goods, gift, metal, stones, precious stones, and so forth and so on. It is believed that that land that was so rich, full of resources, is the present day Zimbabwe. And then Zimbabwe suffers from a resource curse. From these resources that we have, we actually suffer facing corruption. And because of that, now let me look at this relationship between corruption and human rights. So you can understand this relationship as a spectrum. On the weaker side, we have those institutions that describe corruption and human rights, the relationship using very weak terms, like the United Nations, for example. They say corruption undermines the enjoyment of human rights, or it facilitates, or can have grave and devastating effect, and so forth and so on, but they don't want to use the strong language that others are actually on the other extreme of the spectrum. They are already talking of freedom from corruption. That is, corruption is an independent, fundamental right. So freedom from corruption is a right that is freedom from corruption. But in between these two, we have those who believe that corruption is a violation of human rights in and of itself. So there's no need to create a new fundamental right, the right of freedom from corruption, but using existing instruments, we can see that corruption under certain circumstances can lead to the violation of human rights. Okay, I'm going to admit somebody here. with that in mind, let's keep that in mind. I want to look at the key challenges that are facing the government of Zimbabwe today when it comes to asset recovery. First of all, it is important to mention that we have had a change of government. Somebody spoke of Mugabe. Mugabe is no longer in power. There was a military assisted transition that led to the removal of Mugabe. The new government came in before the mafia had a chance to regroup. They started to recover assets. Of course, in this case, they are targeting only those who were associated with the previous regime. So they are targeting those who were in the government of Mugabe. It's not necessarily corruption, dealing with corruption using the rule of law. Nonetheless, the government is trying to do something. Asset recovery for the first time is now high on the government's agenda, but they are facing serious challenges amongst others. Lack of funding, there's no funding, asset recovery is quite an expensive process. There's lack of sufficient information. The government doesn't have information on even in terms of tracking the assets, tracing the assets, and so forth and so on. There is also the slow responses or reluctance from destination countries. Also, given that Zimbabwe is still regarded as or still perceived to be a highly corrupt country. So some states, understandably so, they're not willing to cooperate with this new government. Then there's the lack of technical capacity, despite the fact that, some government institutions have received training, but the majority of them, even prosecutors, those who are key, who are in the engine room, do not have the technical capacity to deal with asset recovery, especially international asset recovery, and lack of remedial processes, no policies, legislation to protect whistleblowers, amongst others. So this now leaves room for CSOs to step in. And why do I focus on CSOs? Because for a couple of decades now, I think probably since Zimbabwe, since the time when we had that land reform, chaotic land reform program, and majority of CSOs, they started documenting cases of corruption, massive corruption and mismanagement that has also caused untold suffering in terms of the enjoyment of human rights on the majority of Zimbabweans. So because of that role that CSOs have been doing, documenting cases of corruption, I think they are in a better position to also assist the government in terms of asset recovery. And there are various roles that CSOs can play in Zimbabwe. I've just mentioned here 4 different roles that the CSOs can play, for example, with raising awareness and research and raising awareness. Then we have advocacy, we also have case management and the monitoring of returned assets. And also thanks to earlier presentation, they spoke about the involvement of CSOs, NGOs in monitoring assets that are returned, for instance, in Nigeria. Yeah. So I will go through some of these points just briefly, quickly, and just to give you an overview of how and to what extent Zimbabwean CSOs can play a role. Let me, yeah. So in terms of awareness raising and research, when I was doing research for this paper, I found out that there is a serious lack of, there's a dearth of information on asset recovery. So what the civil society can do, for example, is start carrying out campaigns, including informing the public about the significance of asset recovery and also the weaknesses that are already in the system that is making it impossible for the government to recover stolen assets. They can also help in fostering, helping also other non-CSO stakeholders, even private institutions, to better understand the roles and responsibilities that they can also play when it comes to asset recovery, because at the moment it's just state-centric. So even auditing firms, other private actors that may be in a position to assist the government are not taking part. It's really dominated at the moment by the state. Then advocacy, also quite important. Zimbabwean CSOs have been frequently carrying out advocacy, persuading and decided sections of the public to undertake specific actions. I can give an example of, when they campaigned to reject a constitution that was not people-driven. So they have been very successful in advocacy. And I think they can also, use the skills that they have learned, fighting for human rights to also deal with this relationship between corruption, human rights, and lead to asset recovery. A good example, or one area I think in which I think that Zimbabwean CSOs can play, for instance, in terms of advocacy, lobby and advocacy, working with international players, with using these mechanisms such as, Magnitsky Act to see when Zimbabwean people are listed under, for example, just recently we have those highly connected politically exposed people working with the government of Zimbabwe have been listed under the Magnitsky Act, I think in the United Kingdom and in the United States, to then see how these states, destination states, can then not only freeze assets of those people, but also then retain these assets via CSOs to make sure that the stolen funds go back to where they were supposed to go in the first place, that is, fulfilling government responsibilities in terms of human rights. The next is on casework and legal analysis. As I've said, that the government is already doing something. So we have a few cases that have been there, I think, dragging through the courts for the past 3 or 4 years since Mugabe was removed from power. And you can see already that the government doesn't have the capacity, especially, as I said, technical capacity to see these cases through to the logical conclusion. So this is also another area where CSOs can step in and try to assist, various government departments that are involved in asset recovery and help them. And where possible, we also do have provisions for CSOs to even, take up litigation, sort of private actors. So this is another area that we can, or CSOs can also step in and assist in asset recovery. Then in the event that assets have been retained, or in the event that there are frozen assets, maybe under the Magnitsky Act or under various laws that may be existing elsewhere, they should also be in a position to then negotiate or lobby those destination states that have frozen Zimbabwean assets, because I understand, if my understanding is correct, the assets can only be frozen to, for a certain amount of time. Otherwise, it will be a violation of a certain fundamental rights, even of the accused people, to have their assets frozen for an unlimited period of time. So they can also use that opportunity where you have assets that have already been tracked, frozen, to then work on how they can be returned back home and be put to good use. And this is also where I differ with the other comrade from Nigeria who was talking about, James Ibori's assets being returned back, but instead of going back to that specific state where they were stolen, where James Ibori was governor, they were returned elsewhere. I think after assets have been stolen, a lot of water can go under many bridges in terms of maybe even reassigning resources that were stolen. So for me, it's just important that, assets should just be put to good use, once they are returned. So it really doesn't matter where exactly they go, as long as they come back to that requesting state where it was stolen, then that really makes sense. And if they can be returned back and be used for any emergency issues, Equatorial Guinea is an excellent example where returned assets have been used, I think, to buy vaccinations, although of course probably they were stolen from money that was supposed to build maybe schools or to provide other services. But you can also just look at what are the urgent issues that are pressing at the time, return assets for that particular use, put them to good use. In terms of, to conclude my presentation, I'd like to say that in spite of the fact that asset recovery is quite a lucrative area, especially for lawyers, private law firms, in Zimbabwe, there is lack of capacity to deal with asset recovery, even at the private level. So this only leaves one player who can, the country with only one option, that is CSOs. So CSOs, given the legal precedents that are available now, increasing international cooperation and also some enhanced capacities, they are now in a better position to assist in asset recovery processes. That said, I think it's also important that they discuss certain key issues before they even try to enter into that territory. I just quoted from a certain paper here, but I'm just going to read through and apologize in advance, that retaining and receiving countries should, in consultation with the broad spectrum of relevant experts and non-state actors find alternative means of managing stolen assets, then the question that I'll pose to the Zimbabwean community, CSO communities, what role can civil society play in enhancing asset recovery processes in Zimbabwe? So first of all, they need to map out that what is it that we are expected, what is it that we are capable of doing, given our current understanding of these issues. And also, how can the human rights-based approach to asset recovery be integrated into the government of Zimbabwe's current processes? So we know that CSOs in Zimbabwe for a long time, for the past 3-4 decades, they've been working on human rights issues, and they have been treating human rights issues, in cell. They were not really seeing the relatedness of things, human rights and corruption, asset recovery, and so forth. So how can they now try to include this human rights-based approach, including in areas such as asset recovery? Then the third question is a number of CSOs, they have developed national principles on asset recovery. I know there is a couple of countries in the Middle East, also Ukraine may also have developed some set of principles. So is it also not time for Zimbabwe perhaps to even start thinking of developing their set of principles that can then assist in terms of engaging with destination countries on asset recovery? And the last point of discussion is that according to Article 35 of the United Nations Convention Against Corruption, any person or entity that has suffered damage, as a result of an act of corruption, should have the right to initiate legal proceedings against those responsible for the damage in order to obtain compensation. To what extent can this provision support CSOs' claims seeking the recovery of assets allegedly misappropriated through corruption? So this is another question for CSOs working on Zimbabwean issues. We have been bringing up claims on behalf of victims of other human rights violations. Can we then use this Article 35 and other existing mechanisms that have been used to, for example, to get redress for victims of civil and political rights violations to claim for the recovery of assets? And with this, I come to the end of my presentation, and I would like to thank you all for your attentive listening. Thank you also, Chair, for giving me this opportunity. Yeah.
Thank you very much, Prosper, for a very interesting, wide-ranging presentation there on the role that civil society can play, particularly set against that sort of transitional context you point there in Zimbabwe. And I think as you were going through those different roles, I was really struck by the symmetry with Catherine's opening presentation on the norm diffusion and both the challenges and gaps there, and the role that CSOs can play in trying to proactively fill those gaps, I suppose. So there's a lot of interesting, I think, conversations to be had there, but conscious that we have one more paper, which I'm looking forward to, because given that it approaches the vexed questions of victims in this process, which can often surprisingly provoke quite furious debate, I will pass over to our final speaker, Dr. Ariadna Ochnio, and I think you've got a PowerPoint you're going to pull up, and then we'll take it away.
Yes, thank you for giving the floor. I try to share my screen.
Great. Yep, we can now see the PowerPoint.
Firstly, I would like to say that it's an honor for me to be a speaker at this conference, and I would like to thank the organizers for this opportunity. It's all the more important in this time when COVID-19 pandemic affects the scientific community, making research difficult. So thank you very much. Today, I'm pleased to talk about the rights of crime victims to recover property in the Polish legal order. You will see the contrast to what, for example, Sarah Brimboff and Rahima Zutembi, previous speakers, told us today about model of asset return. This is because the system of confiscation in Poland is still under development, and we haven't yet reached the point of discussion to which these speakers contributed today. I would like to start my presentation with a few introductory remarks. The causes of criminalization are related to the appropriate state reaction to specific behaviors that are socially harmful. And only the social harmfulness with a certain over minimal intensity can justify the state's reaction by means of punitive measures. And in the properly structured legal system, criminal law should be used as a last resort. Considering all of this, society is always an intermediate victim of crime, even in a situation when we can't identify specific victims. The victim of crime can be an individual, but also social groups, local, national, regional, super-regional, and also international communities. Disruption of the functioning of various social groups can be considered in broad categories of harm. In this context, we can ask the fundamental question: why do we consider something a crime and punish it? And next question: how do we punish for the crime? And the answers to this question should also, in my opinion, serve as a benchmark for justifying the objectives of criminal confiscation in national law. The modern concept of confiscation should primarily take into account the aspect of repairing the social harm caused by the crime. As a consequence, the proportionality of punishing acquires a new meaning and is not primarily focused on the severity of the sanction. Instead, the focus should be on restoring the social balance disturbed by crime. The concept of restorative justice puts repairing social harm first, however, with the involvement of all stakeholders. In due process, the right of its participants, including perpetrators and victims, should be fairly balanced. A system of law where the main beneficiary of recovered asset is the state is a socially unfair system in which confiscation can fulfill its social functions. Given these circumstances, it's legitimate to say that the victim of a crime in the broad sense, individual or social group, should be at the center of criminal confiscation objective. In fact, it seems that in the concept of confiscation adopted in national law, there should be room for two beneficiaries of the recovered assets, the state and the victims, and the state can benefit as an organizer of the asset recovery process as it bears the cost of it. What can be discussed is how to distribute confiscated assets among various stakeholders. However, it is unacceptable when the national confiscation mechanism doesn't take due account of victims' right to recovered assets, even indirectly, with the use of state special purpose funds. Unfortunately, an example of such a mechanism is the forfeiture mechanism adopted in Polish criminal law. At this point, I would like to make a few terminological remarks. Current Polish criminal law, starting with the Penal Code of 1997, which is now in force, uses only the term of forfeiture, not confiscation. However, the institution of forfeiture should be related to the provision of EU law on confiscation, because the difference is only in the nomenclature of legal institution, not in the legal essence. Therefore, I will use both of these terms in the presentation. However, under the previous Polish Penal Code of 1969, there was also a separate legal institution called confiscation, which was significantly different from the forfeiture. But I will say a few words about this historical condition in the next part of the presentation. Now let's move on to the next point. In the Polish legal system, there is no non-criminal confiscation imposed dependent on the perpetrator's danger resulting, for example, from his involvement in organized crime. The institution of preventative confiscation is still not used in Polish law. Confiscation belongs to the realm of criminal law. and there is no in-rem action aimed at dirty assets. We are currently at much earlier stage in the development of the confiscation mechanism than, for example, Italian, French, or English law is. The first major reform of forfeiture carried out in 2003 was motivated by the need to adjust Polish law to requirements of international law. The justification of these changes was also the possible impact on the accession negotiation with the European Union. Poland joined the EU in May 2004. However, the process of Poland's integration had started earlier in 1994. The changes introduced in the Polish Penal Code in 2003 were influenced by the Council of Europe Criminal Law Convention on Corruption and OECD Convention on Combating Bribery on Foreign Public Officials in International Business Transactions. In addition to changes in the regulation of forfeiture, the bribery offenses, active and passive corruption related to sport, election, and private sector were then introduced. As a result of changes, for example, the meaning of the term material benefit has been extended to the benefit of a third party. To sum up, as a result of changes introduced in 2003, the criminal court may order the following types of forfeiture: the classic forfeiture of objects, forfeiture of the instrumentalities or the equivalent, and forfeiture of objects for which prohibitions exist as regards their manufacture, possession, or trade. The court may also order the forfeiture of benefits which were indirectly derived from crime. Moreover, the extended forfeiture and of financial benefits or forfeiture from a third party is possible by applying one of the rebuttable legal presumption. After the above-mentioned amendment of 2003, these types of forfeiture involve a reversal of the burden of proof. But now let's focus on the next issue, the two limited possibilities for direct social reuse of confiscated property in the Polish legal system. This issue is regulated by a special regulation of the Minister of Justice of February 2017 on the list of objects which, in the event of their forfeiture, shall be transferred directly to states authorities other than the head of the tax office. But they are still state entities and not strictly social ones. In order to execute the forfeiture orders, various objects are transferred to other authorities. For example, counterfeit official marks and measuring tools, military equipment, weapons and ammunition, narcotic drugs, and other objects. However, this object can be transferred only to state entities, inter alia government administration bodies, the military headquarters, the police headquarters, the border guard, National Bank of Poland, Central Forensic Laboratory of the police. The problem to be solved at the legislative and organizational level in Poland is still closed possibility of transferring confiscated assets directly to crime victims, social entities in the strict sense, such as charities, NGOs, or local communities. These possibilities are too limited now. An example of this is the possibility of transfer of the confiscated assets of scientific, artistic, or historical value to a museum. The decision on the transfer is made by the criminal court. Nevertheless, even this very narrow possibility of direct social reuse of property by a museum is relatively new, as it was opened in 2016. Another example is the Polish anti-COVID legislation, which recently introduced a provision enabling the social reuse of property. New Article 232b of the Code of Criminal Procedure was added in 2020 by a special act known as the Anti-Crisis Shield. This is an act amending the Act on Special Solution related to the prevention, contraction, and combating of COVID-19 COVID-19 pandemic. This object of importance to public health or safety can be now transferred to the medical entities, state fire service, armed forces of the Republic of Poland, police or border guard. This legislation reflects the cause in the field of social reuse of property in Polish legal system. The provisions are dispersed between the Code of Criminal Procedure, the Executive Penal Code, and special regulation. However, an important question arises as to the juridical nature of this anti-COVID regulation. If this regulation serves the purpose of improving the fight against the COVID-19 pandemic, it should be a temporary regulation, but it's a permanent regulation. In my opinion, there is a risk of its abuse in the future by expanding the interpretation of the meaning of the term security. For example, under this new regulation, some objects were handed over to the Polish border guards facing complicated problems on the Polish-Belarusian border related to a large influx of migrants. In the Polish legal system, there is a need to create transparent mechanism for social reuse of property by introducing permanent regulations corresponding to the contemporary challenges of fighting crime, in particular organized crime. This mechanism should also meet social expectation regarding the function of criminal law and also the function of confiscation. This obliges the legislator use of confiscated assets in such a way that it performs a restorative function. And at the heart of this mechanism should be the direct and indirect victims of crime. Another question arises, do the recent changes indicate a change in the approach to the forfeiture mechanism in national criminal law? Unfortunately, no, because the rights of victims of crime are still not taken into account in the forfeiture mechanism. I think that due to the time constraints, I don't discuss the historical determinants. Now I come back to this at the discussion. Okay, so now let's get to the heart of the issue. How to enable social reuse of confiscated assets? Under the current legal framework, the confiscated object, property benefit, or its equivalent becomes the property of the state treasury as soon as the judgment becomes final. Moreover, the forfeiture of objects, the benefits, or its equivalent is excluded if these assets are returned to the victim or other authorized entity. The forfeiture mechanism is therefore not used for the purposes of the subsequent restitution for victims of crime. In my opinion, this approach to the confiscation mechanism in Polish criminal law is archaic, doesn't correspond to the EU law, and doesn't meet social expectation regarding criminal law. And that is a problem, that in the concept of forfeiture adopted in Poland, that restitution for crime victims is excluded from this mechanism. The current legal solution makes social functions of criminal forfeiture impossible. The restitution is possible only within the traditional framework of compensatory measures adjudicated in criminal cases, for example, the obligation to compensate for damage. What are the consequences of this status quo? Assets recovered by forfeiture become the property of the state treasury and cannot be transferred neither directly nor indirectly to the victim of crime. Instead, the procedure should only provide for a temporary transfer of the confiscated property to the state coffers to its disposal and not to ownership. The forfeiture mechanism should take into account the victim's right to restitution and compensation, and victims should seek the satisfaction of the right directly from the assets recovered through forfeiture. This is justified by the procedural facilitation due to the application of presumption when ordering extended confiscation and confiscation from third parties. To this end, the decision to release the assets should be moved to the stage of the executive criminal proceedings. And this stage of the proceedings, a decision should be made on how to dispose of this asset, what should be returned to the victim or social organization, and what should be transferred to the state treasury. It seems that the right choice would be to create in Polish system a central body empowered to dispose, manage, and reallocate confiscated assets. Reforming the national forfeiture mechanism in terms of victims' rights is also important from the perspective of EU regulation on the mutual recognition of freezing orders and confiscation orders. A significant novelty introduced by this regulation is that the rights of crime victims to compensation and restitution take precedence over state rights. Recital 45 of the preamble to that regulation state that rules for the disposal of frozen or confiscated property should give priority to the compensation of and restitution of property to victims. As I tried to show, milestones in reforming the Polish forfeiture law have so far been achieved under the influence of international and EU law. The ambition to meet the standards of EU law was of great importance during the previous changes in Poland. Therefore, the question arises whether a sufficiently strong impulse from European Union law is still necessary in order to reform Polish mechanism of forfeiture. And the current approach in EU policy limited to recommending member states the social reuse of recovered assets is highly inadequate and should evolve towards introducing a commitment in this field. According to the directive on the freezing and confiscation of instrumentalities and proceeds of crime of 2014, member states shall consider taking measures allowing confiscated property to be used for social purposes. It follows that member states should only consider and aren't obliged to introduce such measures. The obligation to allow the distribution of recovered property for social purposes should become a strong obligation for member states under EU law. This is even more important for countries like Poland, which are struggling with a lack of funds in the state budget and facing high inflation, forcing various aid measures by the state. Unfortunately, this situation makes the state more interested in acquiring assets also from a source such as forfeiture or confiscation, because the political will to transfer this asset outside the state coffers directly for social purposes is weakened in such a situation for obvious reasons. Therefore, the impact of EU law on Polish law in this area is limited in the current economic situation. At the end of the presentations, the forfeiture mechanism adopted in Polish criminal law should be reformed towards opening the social functions of forfeiture. The beneficiary of the forfeiture mechanism
be better to. First question from Eva is for any of the speakers, but suggest it might be more closely run to Catherine to talk. Do CSOs have the necessary bureaucratic mechanism of political capital in your jurisdiction study to engage with asset recovery cases and advocate for democratic restitution? If not, how can the international community or host jurisdiction those to open up pathways for democratic restitution? So that's a really good question, and I'd be interested to know if I mean I think both probably Prosper and Catherine might have.
Maybe I'll start because I also have a question on this for Prosper, so I can provide my answer and then loop in with a follow-up question to him. Eva, thank you for the question. I think it's a great question. Yes and no. A lot of civil society are highly professional. They're really experts, and in many cases, they're the ones who are really pushing these cases forward. So in that sense, yes, they have, as you wrote, some degree political capital. On the topic of bureaucratic mechanisms, I think there's still some room for improvement here. There is, of course, a formalized way for civil society organization through the UNCAC coalition and through their role on the Conference of State Parties and things like this. but those roles are restricted and they could be improved. Lastly, I think that there's a really important international component to this degrees, and I think this actually draws in Ariadne's talk as well. There are varying degrees of expertise and of just practical experience on asset recovery and return cases in different countries. And so from my point of view, what's really essential and helps us all from reinventing the wheel every time are international networks. And so that's on the requesting and the return side, bringing civil society organizations together. There's a new case bringing civil society organizations who have prior experiences on similar or just other cases in. And so just to add that question on to Prosper, what do you think is the future for CSOs in Zimbabwe now? And do you think that this international networking component is part of?
Well, over to you, Prosper. A few questions there.
Oh, okay. I was still trying to figure out how to work them. It's a very good question. So to be honest, the thing is, I think for the past 3-4 years, I was really looking like a madman when I was trying to let them know or to even get between just corruption and human rights violations. Everyone was focused so much on civil and political rights violations in Zimbabwe. Those were the main issues. Also, some challenges that are caused by what has been called NGOization is that most of these NGOs that are funding Zimbabwean CSOs from the donors, not a politically correct term, perhaps, let's say funding partners who are assisting Zimbabwean civil society organizations, they give them a very specific agenda. So we have guys like the Human Rights Watch. For a very long time, they were only focused on civil and political rights violations. Amnesty International, the same thing, mainly focused on abductions who have been arrested arbitrarily and so forth and so on. So it took a long time before they could start to see that relationship. And I was really at the forefront trying to say, let's also look at it from this perspective. Let's also try to work with the government. Okay, we work against and also sometimes with them when they're talking about issues of corruption. On the other side, we have the government that was talking about corruption. So even that military assisted transition, or to put it bluntly, the coup that occurred in Zimbabwe, the reason that was used to justify the coup was to arrest corrupt people who were around Robert Mugabe. And I was saying, let's then also say, okay, we want to help you address corruption issues, and then we'll see how we can then also mainstream human rights issues. So at the moment, to just explain this in a succinctly, at the moment, there isn't really that much, but it's they are beginning to see that relatedness of things, corruption, human rights issues, and then asset recovery. So last year, on the other, another additional information, last year Zimbabwe was part of the UNCAC review. And this round, the current rounds of reviews by the United Nations Convention Against Corruption, they are also looking at chapter 5, asset recovery. So that also brought the issue of asset recovery on the fore. And I happened to be one of those few people who were consulted to draft the civil society shadow report. I can tell you, I only received assistance from a number of organizations. You can count them. I can count them with my single hand, who assisted with information for that shadow report to help with the UNCAC review on Chapter 5 on Zimbabwe, because they don't have any. They are not aware of the role they can play in regards to asset recovery. And just today, before this session, I was now trying to link up with this network of Zimbabwean organizations that is based in Brussels, called Zimbabwe Europe Network, ZEN. So they're working with a couple of organizations, but they are based in Brussels. They were doing that at the height of human rights abuses in Zimbabwe during Mugabe's era. They were lobbying the EU, UK parliamentarians, and so forth and so on. So I'm trying also to see how we can start to talk about this issue. And then last year on 9th of December, International Human Rights and Anti-Corruption Day, I organized a very short a seminar where I discussed this paper that I presented today but only a couple of organizations attended. So, but what we are going to do is that we are going to publish that paper via the local chapter of Transparency International and see if we can invite a broader group now of non-state actors, not only NGOs, but even the media as well, other grassroots organizations, to see how we can get them to start discussing, start talking about asset recovery. So this is the current state of affairs in Zimbabwe. Asset recovery is an issue that is not well understood. Those who have read or they know about this term, they just think, okay, this is an area that is reserved for state institutions. And even among state institutions, it's only one institute that is working on asset recovery, that Zimbabwe Anti-Corruption Commission, which for a long time was just useless under Mugabe, and now he has been reconstituted, but only to fight political opponents of the current regime. So, well, this is the situation we're facing now in Zimbabwe.
Thank you very much, Prosper. I see a hand raised from Simeon in the audience, our previous panelist. If you'd like to come in and now, that would be great. Oh, I'm not sure if we're having problems with your connection, Simeon, because I can hear a slight buzzing noise, but I can't actually hear your question or comment. So it might be that your connection has got a problem. I don't know if it's possible to write the question or comment in the sidebar, and I can be happy to read it out. I'll just give you one more chance to see if we can hear you now. Simeon, can you try again? No, unfortunately, we're not hearing. So if you could just maybe oh, yep. Simeon, can you hear me?
Hello.
Yep, you're clear to ask a question.
I have my internet connection is unstable. Can you hear me, please?
Yes, we can. You go for it now.
Hello, can you hear me?
We can hear you.
Hello?
If you're able to. Yes, we can hear you. So please ask a question.
Okay, please. It's not really a question. It's a comment to Dr. Prosper's presentation. In the course of his presentation, he suggested that it doesn't really matter who actually got the repatriated assets, that it is delivered to a country is enough. That is what he was trying to say. But as you know, it's not so. In the case of Nigeria, it is not so. Nigeria is a federal state. I know that Zimbabwe is a unitary state. The assets that have been returned to Nigeria, they have, in the past, they ultimately got to the particular state within the Nigerian states. So it is just like, for example, assets from the US, originally from New York, then stolen and taken to Germany. Then they've been restored to the US, and now they've been taken to Florida. They have to go back to New York. So it is not we are talking of justice, we are talking of human rights. So if you are looking, if the UNCAC says that assets must be returned to victims, victims must be identified. If Nigeria has received assets belonging to Nigeria in the eye of international law, then those assets must be taken to the ultimate victims. It is not enough for the UK to deliver Ibori loot to Nigeria, and Nigeria will now, because of politics, domestic politics, deny the ultimate victims of those assets. Please, just for the record. Thank you.
Thank you, Simeon, for that. I don't know, Prosper, if you wanted to add anything there. just in response.
Sure, indeed. And let me say that I don't want to undermine any efforts that have been done so far. And I also liked very much your presentation, Simeon. And I was also one of the people who were very angry last year when the lady from the ambassador, Katrina Lang, announced that, oh, because of this MOU between Nigeria and the United Kingdom, we are now taking this money to build a bridge. Where else? And I was like, but the money was stolen from this state in the first place. And I thought, look, this may be self-defeating if we want to be very particular like that. After all, corruption happens in secrecy behind closed doors and drawn curtains. We may then end up fighting this huge battle of trying to figure out exactly who is the victim in this case. Meanwhile, the assets are just somewhere else in the destination country because we are still busy fighting, trying to identify the victim, the actual victim, direct victim, if we can get them. Large-scale corruption, universe of victims. The whole country, everybody is a victim if we have to look at it from that way. If we even look into the issue of Nigeria, where probably 90% of all your money is coming from oil. So you can even...
Excuse me, no, Nigeria is a federal state.
I understand.
That
Let me just finish. Then money is fungible.
Okay.
Money is fungible. Yes, you see, you can even steal money from somewhere else. You take money from the World Bank, you use it to cover up for the money that you have stolen over there. So those are some of the issues. And I believe that if we are to be very strict in terms of we want to identify the exact victim of corruption, we are throwing spanners in our own way. So rather, let's get the money back. Development is development, you know, but at the same time, I want to, maybe we can.
Actually, at this point, if I could actually bring in, because I think it's a good moment to maybe bring Ariadna back in, because actually the sort of little debate that's emerging here is not one that is unfamiliar. And if I could throw in an additional example that I'll speak about tomorrow, working in Uzbekistan, obviously the large asset recovery case being dealt with there involves Gulnara Karimova, the daughter of the former president, and there's almost $1 billion of assets abroad that have been seized, and they're being returned in tranches. Now, the question there, when it comes to who are the victims, obviously there's a strong argument saying the people of Uzbekistan are the victims, but also we have creditors of Ms. Karimova, or alleged creditors of Ms. Karimova, who are saying no, they are the victims who should obtain priority because they lent her companies in substantial amount in trade credits. I believe there's German, Ukrainian, and they're after hundreds of millions of dollars, and they're arguing that they should have first right to the recovered assets because they are the most harmed and direct victim, and that would in effect leave the people of Uzbekistan the second to get whatever's left over. Now, at the moment, my understanding is the Swiss courts have rejected those interventions. But I want to check with, with Arianda, do you think there are legal mechanisms or institutional mechanisms, and are they being talked about in Poland, where actually when you get down to it and there could be multiple competing claims, how do you deal with that? Have you looked at that in your own research?
Yes, I'm also a public prosecutor, so it's a very difficult problem with the conflicts of rights, but it's all the more it's more difficult in cross-border cases because we lack the procedural solutions, clear provisions, what we should do. So, we try to do something, and after we came to the conclusion that it's impossible. It's impossible to return. It's impossible to do this because we lack appropriate regulations. It's like with the UN Convention against Corruption implemented in Poland. There aren't, we haven't procedural provisions to return assets to other country. So, okay, formally we are the part of the convention, but it doesn't work. So it's very important to secure due process, fair procedural solutions for these kind of situations. And you know, at this conference, the level of discussion is high, you know, and in Poland we have to secure the basic rights of victims, as I said, because you have to understand our situation that in the years 1944 to 1989. Poland was a non-sovereign country, and now we have constitutional crisis in Poland, and this crisis has an impact on criminal law and on criminal procedural law. So everything now is more difficult and more complicated, and it's very visible in cross-border cases. So I don't know if it's a good answer, but in the legal practice is always difficult when you have two victims, or you can't identify all the victims. How should you dispose the assets? And when you have a law, you know, when the restitution is excluded from the forfeiture mechanism, and you can't use the forfeiture, you can use the legal presumption, use it in extended confiscation and confiscation from the third parties. The effect is that the asset that you have are of the lower value. No, so it's a big problem, and practical problems and also theoretical problems to resolve.
Yes, no, thank you. And I agree. I mean, I thought when you mentioned earlier, I mean, even bringing in concepts like restorative justice, it does raise questions. You know, when you look at a word like corruption, the very sort of classical definition is that it's a harm to public trust. And therefore, if you're using the stolen assets, the recovered assets to repair public trust, well, what does that mean, and how do you do that? Certainly, in my experience in Central Asia, there's been reticence on the part of governments like Kazakhstan and Uzbekistan to see any of the money being invested in processes that might restore public trust, and it's more being spent on non-offensive things like, you know, nice charitable pursuits, but nothing that actually addresses the critical issues of corruption. So I just want to, just mindful of the time, there's probably a chance for one last quick question. If anyone has a question, please put your hand. If not, I have one that I'd like to throw. Maybe more, this one's again, maybe more Catherine Prosper's way. And it actually arises from the discussion before, and that is, and I think whether you're in civil society, and it's true to the academia, in order to do that important job that I think, Prosper, your talk really covered well, the really significant range of contributions that civil society can make. And I thought that sat well against Catherine's talk, because you saw how it could impact through that norm diffusion process as one example. But of course, civil society, you know, and if we include that, and academics as well, can't live off air. You know, they're made by people who need to make livings, and so they often rely obviously on funders, on donors, and that creates in a way a sort of conflict in a way, because, you know, as we're all acutely aware, donors want to see impact when they give funding to civil society. And I guess the challenge there is that when you're trying to make impact in asset recovery, state parties have all the cards. And so is there a temptation there to have to, and it's true with the academia as well, where our funding is very much dependent on impact. And it's much easier to demonstrate impact when you partner with the state, you accommodate the state, and you work in their processes. It's much harder to prove impact when you say, actually, I'm going to confront them and act in a very adversarial manner. So is this kind of issue around, is there an issue here that civil society is constrained bit by the donor models that they're dependent on? Or am I being unfair? And that's a genuine question. I'm not sure of the answer. I don't know if anyone wants to jump in first. Probably.
Prosper, do you want to take that first, or?
Yeah, indeed. It is largely, donor driven. Always the successes, even sometimes also the not so successful cases or anything that happens in there is also attributed to the issue of funding, especially with NGOs. So the thing is, they need to work with the states when it comes to asset recovery. We still know that all these processes are state-centric. But what I'm seeing now, because we also have non-state actors being involved more in the issue of asset recovery, not only that, we are also witnessing these extra mechanisms. The Magnitsky Act, I gave an example where you have now mechanisms targeting corrupt people, money is frozen. And if you can have an NGO that can then say, look, our government is still very much corrupt, they're still very much abusing human rights abuses. In case, if you return this money to this same government, it's going to get back into the same coffers where that is not porous coffers where to still get restolen again. What we can do now is to encourage civil society organizations not only to depend on traditional funding, but also use asset recovery as an innovative way of funding their projects. So you say, okay, we are running low on funding medications or whatever projects they are doing. Then they try to work with those destination countries that have already, especially those that have already frozen assets, and they have the money that is there available. And we know that the Magnitsky Act, they're talking about the link between corruption, human rights abuses, and they say we have even victims of that same person. We can, in Zimbabwe, I'm sure, we can even show how people are victims of certain incidents of corruption, of people who are listed or who have been listed under the Magnitsky Act. So civil society can actually should start to think innovatively on how to engage with asset recovery processes as another way of funding their projects. Post-pandemic, most of the funding may even run dry. So there is this other extra funding sitting in European banks that they can also have access to. So this is the way I want to look at this issue of funding. But of course, it's still very much difficult for civil society to do it alone. You still need the state. You can't just, even if you look under the UNCAC, you can't just claim a civil society to say that we are victims of corruption, therefore, we are representing victims of corruption, and we need the funding to be directed to us.
Great. Thank you, possibly. That's an interesting idea there. Thank you for that. And I'll finish off nice. We're coming back with full circle, back to Catherine again to conclude. Did you have any comments to make on that last question?
Maybe just a few brief ones, because I feel like this question could deserve its whole own conversation. It's a big question. It's an important one. So first, I just want to acknowledge sort of the fundamental truth of this question. Yes, absolutely. Civil society organizations are not comparable entities to the state. They don't have that kind of stable funding base. They don't have that kind of power base. Yeah, so I think that this is an issue. However, I do think that there is a lot of support going to civil society organizations. And I'm speaking, of course, from my own background here, because I've been on the funding side before. There are resources being directed that way, but we can also have a separate conversation about how well those resources are being directed and if they're being directed to the right parties. For example, I'm in favor of institutional funding over project-based funding that enables an organization to grow over time rather than constantly having to chase new grants. And then just finally, briefly, to respond to Prosper's idea, which I think is an unusual innovation, but at least for my region of experience, which is the Russian-speaking part of the world, former Soviet space, I could immediately see how that could be really risky, because you would have states parties nominating only gongos, only sort of government-controlled NGOs to participate in the process and profit off the process. So I think it's a lot to unpack there.
Yeah, yes. Well, I was reminded there of research done by a colleague, Thomas McManus, who looked at the Trafigura case, where the large compensation payments, which were navigated through NGOs, and it turned out the NGOs were actually ended up becoming, I think if I remember correctly, organized crime fronts, who were, so, there's always that risk there too. So, but really, exactly, I think you're right, and that's probably could be an entire panel topic, the one you raised there, and I think you even point to some interesting solutions that do sound like they would be useful. So on that note, if I could just thank all the panelists again for a series of fascinating papers and some very thought-provoking, and to thank the audience, and to say tomorrow 2 o'clock we start again, where we will put a critical lens up to international AML, because you don't get asset recovery if you can't identify them and seize them in the first place. And so we'll look at that often tenuous relationship that's between the asset recovery world and the AML world, and hopefully there'll be some interesting critical papers on that front tomorrow. So on that note, thank you very much. It's been a brilliant session, and I look forward to seeing everyone tomorrow.